Continuing the previous discussion, let us continue the analysis of case studies. Miss Rekha contracted with Mr. Rohan to sing in his theatre for 6 nights for a fee of 30,000 rupees payable after the last performance. After singing for first 3 nights, Rekha willfully absented herself without any valid reason and refused to perform for the remaining 3 nights. What are the legal consequences of Rekha's refusal to perform the contract wholly? Students, what happens when the promiser is refusing or failing to perform substantial part of the contract, which obviously gives right to the other party to rescind it? So this particular question is arising from section 39 relating to the performance. So when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct. So this is also very important. He should not have signified his acquiescence or acceptance by word or conduct, otherwise he will lose the rights. So the consequences of this particular Rekha's refusal to perform is that Rohan is discharged from the contract and he is entitled to claim damages from Rekha for non-performing. And also in this case, Rekha cannot claim any payment because in the quantum merit we discussed that to the as much as deserved or as much as earned, it has to be compensated. But in this case, this 30,000 rupees is a lump sum amount and it is not a divisible contract. So this is an indivisible contract which makes a lump sum payment upon the performance of the promise. So generally for lump sum contracts, part performance does not entitle the performer for the payment. So the Rekha also cannot claim compensation or any payment from the other party, Rohan. So this is the explanation. And moving on to the next question, Jagdish entered into an agreement with Satish to purchase his house for 20 lakhs within 3 months. He also paid 50,000 rupees as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Satish's house was demolished. When Mr. Jagdish was informed about the incident, he asked for the refund of token money. Referring to the relevant provisions, decide whether Jagdish is entitled to the refund of the amount paid. See what happens when the contract is made, which becomes impossible. Here in this case, what has become is, because of the legal implication, the agreement has discovered to be void. Because of the encroachment drive, the local administration, the government has acquired and demolished the house. So in section 65 talks about this. When an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage or under such agreement, he is bound to restore it. He is bound to return it or to make it compensation for the person from whom he received. In this case, Jagdish, who has entered into a contract with Satish to purchase house, it could not be completed. The sale could not be completed within 3 months. He had only paid a token advance, but it was not completed. Before the completion of the sale, the house got demolished. So this event has resulted in impossible act. So hence, in this case, Jagdish is required to refund 50,000 rupees token money paid to Satish, as the contract to sell the house has become void due to the demolition, and which has become impossible to sell the house on the part of Satish. And the third situation is that where a party to a contract refuses altogether to perform or disabled from performing is part of it, the other party has right to rescind it. So this is again a plain question which there is no case study. When a party to a contract refuses altogether, this is basically an anticipatory breach. So what happens when the anticipatory breach of contract happens? The promisor, when refuses altogether to perform his promise and signifies his unwillingness, basically, even before the time of performance has arrived, the other party has option. The promisee uh, is having an option either to treat the contract as cancelled or cancelled, and he can sue for the damages, or he has option to wait till the due date. Wait till the due date. So when he has cancelled and sue for the damages, there is no other consequences. But however, when he has treated the contract as operative, and if he is waiting till the due date for the performance, then the other party responsible for the consequences of non-performance, but in this case he will keep the contract alive for the benefit of the other party as well as his own. And if he decides so, the other party has time to perform, and when he is performing, he has to accept it. And also one more situation arises here is that the other party can claim the benefit of supervening impossibility when the contract is treated as operative, and if the subject matter get destroyed, then he cannot claim damages. So the defaulting party is relieved from the absolved from the liability because of the destruction of subject matter, and because the contract has become void. So this is the consequence of waiting till the due date. The next question is, Mr. Lal, who runs a successful grocery store in a locality, sells his business to Mr. Gupta. The sale agreement includes a clause stating that Mr. Lal will not open a similar grocery store anywhere in the same city for the next 3 years. See, this question is basically coming out of section 27, where that every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind to that extent is void. Meaning, the agreement which restrains the trade is void. The law basically it is aiming to protect the freedom of the traders and prevent monopolies. However, there are certain exceptions in this case. Generally what happens, the restraint of trade is void. Generally, the restraint of trade is void. But however, there are certain exceptions. One such exception is that the sale of goodwill of a business. In this case, when Mr. Lal, who was running a successful grocery store, has sold his business to Gupta, when there is a sale of goodwill, uh, he has put a condition that he should not, the Mr. Lal will not be opening should not be open a similar grocery store anywhere in the same city for the next 3 years. The law carves out the exception that the restraint of trade is void, but however there are exceptions with respect to the sale of goodwill. But however, in this case, if the court finds the restrictions are reasonable, then it is valid. But however, if the court finds these restrictions, that like for example opening a similar grocery stores anywhere in the same city, this is a restriction, and for the next 3 years this is also a restriction. If the restriction is reasonable, then it is valid. But if the court discretion states that the conditions put on the restraint is unreasonable, then it will be treated as void. So it is no doubt restraint of trade is void. But however, exceptional cases when the sale of goodwill is there, you can keep that such restrictions. But however, such restrictions have to be reasonable. Next question, Mr. Singh, who is heavily intoxicated after attending a party, agreed to sell his valuable antique painting to Mr. Roy for a significantly lower price than its market value. The next morning, when Singh regained sobriety, he was shocked to learn about the agreement and refused to proceed with the sale. Can Mr. Singh legally refuse to proceed with the sale of the painting? Analyze with reference to the section 12. Section 12 here talks about that, where the concept of a sound mind person. See, generally, what happens, the parties to the contract must be competent enough. So, in order to become a competent, the parties must be major, they must not be unsound mind, and they should not have been disqualified by law. So, out of these three situations, the law requires the contracting parties should be sound minded. So in such case, when the person is not sound, the contracting party, if it is not sound, then the contract is treated as voidable. In this case, if the Mr. Singh was so heavily intoxicated at the time of agreeing to sell, and so that he was incapable of understanding the nature and terms, and if he is unable to form a rational judgment about its effect on his interest, then he can argue that he was not of sound mind for the purpose of entering into a contract at that specific time. However, the burden of proof lies on Mr. Singh, that he has to demonstrate, matlab he has to prove that he was not in a position to understand, and so that to support his voidable contract um, voidable contract contention, he has to prove that he was not in a position to understand the terms, and if he successfully, if it is proven, then he can cancel the contract. So on the other hand, if the intoxication was not so severe as to completely deprive him of his understanding, the contract might still be considered valid. But however, the courts will examine the specific circumstances of each case, whether the Singh's intoxication rendered him incapable of contracting within the meaning of section 12. Next situation is that this is for carrying 5 marks question. So Ajay had running account with National Bank Limited. He took 3 separate loans, 2 lakh on 5th January, 1 lakh 15 on 20th February, and 2 lakh 50,000 on 15th March. On 10th April, if he deposits 4 lakh into his account without giving any instructions regarding the appropriation of payment, Ajay has not given any instructions regarding the appropriation, and also bank also did not make any specific appropriation. Later, the bank claimed interest on all the 3 loans. Ajay argued that his payment should be adjusted against the first 2 loans completely, discharging them, and partially against the third loan. The bank contended that the payment should be appropriated proportionately across all 3 loans. Discuss in light of the provisions of the Indian Contract Act. Students, this is basically question arising from section 61, where neither the debtor nor creditor makes any appropriation. In the given situation, the Ajay also has not given instruction, and the bank also has not arranging for the appropriation. In such case, the law states that it has to be applied in discharge of debts in the order of time. In the order of time. So it should not have been done proportionately. Matlab, if the transactions happen on different dates, in the order of time it has to be applied. So if the debts are of equal date, then the payment shall be applied proportionately. If the debts are taken on the different dates, it has to be applied on the order of time. So in this case, when Ajay has deposited 4 lakhs, the first 2 lakhs will be apportioned to the first loan, and the remaining balance 2 lakhs, it will be appropriated to the 1 lakh 50,000, and the later 50,000 has to be appropriated towards the third loan. So this is how it has to be appropriated towards the loan amount. So the bank's contention that the payment should be appropriated proportionately across 3 loans is incorrect, because it has to be chronologically appropriated and not proportionately. And Ajay's argument that his payment should be adjusted against the first 2 loans completely and partially against the third loan is correct under section 61. And also, according to the Clayton's rules, which is embodied in the section 61, also states that Ajay payment of 3 lakhs should be appropriated in the manner as is suggested, completely discharging loan 1 and 2, and partially settling the loan number 3. And next question, Prakash, a leading political party member who have agreed to pay 55 lakh rupees to Mohan for securing 100 votes for him in the upcoming election by bribing the voters. After Mohan fulfilled his part, Prakash refused to pay, arguing the agreement was illegal, and Mohan was approached you as a legal advisor. Advise him with relevant to the relevant provisions of the Indian Contract Act. So whether he can recover the money through a legal suit and discuss the legal principles. Students, this question is arising out of section 23, which explicitly states that when consideration is unlawful, if it is forbidden under law, or if it is of such nature that if it defeats the provisions of law, or if it is fraudulent, so many reasons have been enlisted in section 23. In this case, the agreement by Prakash, a leading political party, to with Mohan is actually a corruption in the electoral process, isn't it? So this will defeat the provisions of law as per the election related law. So section 24 also clearly states that if any part of the consideration for one or more objects, if it is unlawful, then the agreement is void. Since Mohan has voluntarily participated in an illegal act, he is equally at fault. The law will not come to his aid, and it is not enforceable also. Therefore, Mohan has no legal remedy to recover the promised amount of 5 lakh rupees from Prakash, and the courts also will not entertain such suit, as it would amount to enforcing an agreement that is clearly opposed to public policy and illegal. Next, Raj, a carpenter, voluntarily repaired the broken furniture of his neighbor without being asked to do so. So this is what we call it as gratuitously. Without being asked to do so is gratuitous in nature. 2 months later, impressed by Raj's work, Suresh promises in writing to pay 5,000 rupees for the repairs. When Raj asks for payment, Suresh refuses, claiming that since he never requested the repairs initially, there was no consideration for his promise to pay. Advise Raj whether he can legally enforce Suresh's promise to pay 5,000. Explain the relevant provisions of the Indian Contract Act regarding the consideration. This particular question is arising out of no consideration, no contract, and its exceptions. So section 25 talks about that essential elements of the consideration is that it must move at the desire of the promiser. In this case, the Raj has repaired the furniture voluntarily without the request of the Suresh. So hence, it would normally not constitute a valid consideration. It is not a valid consideration as per section 25. But however, when he has promised to compensate for the past voluntary services, so section 25 2 talks about this exception classification, where when the person is promising to compensate wholly or in part, who has already done something for the promiser or something which the promiser was legally compelled to do. In such a case, the Raj voluntarily repaired Suresh furniture, where subsequently Suresh promised to pay, where the promise was also made in writing. The situation precisely covers under this section 25.2. So therefore, Raj can legally enforce Suresh's promise to pay 5,000 rupees, despite the fact that service was rendered voluntarily without Suresh's initial request. And the fourth question here is, Master Sohan, a 17-year-old, is studying at boarding school. The school provides him accommodation, food, and tuition. His father, Verma, who has failed to pay the school fees of 1,50,000 rupees. The school management now wants to recover this amount from Mr. Verma, arguing that these were necessary supplies to his minor son. Mr. Verma contends that Sohan is a minor, he is not liable for any contract, and consequently neither he is. Examine the validity of the school's claim against Mr. Verma and considering the provisions of Indian Contract Act. Section 11 specifically talks about the contracts with minors. So when the minor is generally not a competent person to enter into contract, but however, if it is beneficial to him, if he is a promisee, then the contract is valid. So section 68 talks Mr. Verma about the reimbursement of supply of necessaries. So, supply of necessaries, minor is not personally liable, but however, minor's property, if there is anything, then minor's property is liable. So, section 68 talks about the person who is, when the person is incapable of entering into a contract, and when you supply necessaries to them, and if it is suited for them, and if it has to be appropriate to the life of the incompetent person, then in such a case, you can recover from their their estate, the incompetent person's estate. They are not personally liable. But however, in the case of Mr. Verma's case, the school management can have a valid claim against Verma's property to the extent of reasonable value of the supply of necessaries to the master's son, Master Sohan. Mr. Verma's contention that he is not liable at all because his son is minor is incorrect. The law carves out an exception for necessaries. If the uh, uh, parent, if the father, Mr. Verma, is acting as a principal and Master Sohan is acting as an agent of Mr. Verma, then the principal, or that is Mr. Verma in this case, his father, acting as a principal of Mr. Master Sohan, he is liable to the acts of the uh, Sohan, even though Sohan is a minor. So I hope you all have understood these case studies, and if you require the detailed explanation or model answers for these questions, kindly ping us your email ID in the in this video. I hope you all like this video. Please like, share, and subscribe our channel, Lathore Academy, and please do watch our subsequent videos also, and kindly get back to us if you have any doubts. Thank you.